Hello and welcome everybody to the inaugural event in the Justice Collaboratory's Fall 2021 Policing Conversation Series. The series examines some of the most significant structural barriers to policing reform, and today's event explores the preemption problem faced by reform-minded cities and towns, including the legal and political obstacles they've faced from oppositional state governments and how those obstacles can be surmounted. Joining us today are three of the country's leading experts on preemption and local law. We have Nestor Davidson, the Albert A. Walsh Chair in Real Estate, Land Use, and Property Law, and the Faculty Director of the Urban Law Center at Fordham Law School. We have Richard Briffault, the Joseph P. Chamberlain Professor of Legislation at Columbia Law School. And we have Rick Sue, Professor of Law at the University of North Carolina, Chapel Hill School of Law. Because we only have 1 hour today, I'm tempted to just dive right into the questions that we have for today's topic. But before we do so, I don't want to assume any kind of knowledge on the part of our audience members. This topic can be very technical in nature, so I'd like to ask some preliminary questions to introduce everyone to exactly what it is that we are talking about today. So Professor Briffault, the first question I'll direct is to you. And can you just please explain for us, what is preemption?
Sure. And by the way, thank you very much for inviting me. I'm very happy to be here. So preemption is a way of talking about what happens when two levels of government, both of which have some legitimate power in an area, come into conflict. There's federal state preemption. There could be federal local preemption. And then what we're going to be talking about today is mostly state local preemption. So the idea is that in state local preemption, the state could legitimately pass a law on the subject. It could be some kind of public safety issue or a public health issue, or the local could legitimately pass a law on the subject. It falls within the scope of local power under state constitution. But in this case, they've both passed a law on the subject, and they are arguably in conflict. And so preemption involves really two questions. One is there a conflict? And if there's a conflict, who wins? It tends to be, preemption law tends to focus primarily on is there a conflict, because in most states, most of the time, and we can get into why this is as the program goes along, the state wins when there's a flat out conflict between state law and local law. So a lot of the action in thinking about preemption has to do with deciding whether or not there really is a conflict. But both issues really matter. Is there a conflict? And if there is a conflict, who wins?
Thank you. And in what areas do local governments tend to have the greatest power, or in what areas do they tend to be the most preempted by state authority?
Well, the areas where they tend to be the most active would probably be land use, maybe housing regulation, zoning, kind of things that deal with the physical appearance of a city. But they're active in many other areas, from consumer protection to public health, to sanitation, to public safety. The areas where there's been the most conflict in the last 10 years, and the last 10 years has been a period of rather intense conflict, kind of run across the board. And some of them reflect increased activism by many progressive cities, and also increased backlash by some relatively conservative states. So we've seen very intense preemption conflicts in areas involving workplace regulation, local governments that want to have a higher minimum wage than the state wants, or that want to require employers to provide paid sick leave or paid family leave, and the state doesn't want that, or other aspects that promote kind of worker rights. Fair scheduling rules, that's been a big area. Another area of conflict has been environmental regulation, including so-called ban the bag laws, when local governments want to ban plastic bags and states ban the bans and try and prohibit that. And in other areas where local governments have tried to promote resiliency and states have said no. A lot of conflict in the area of firearms. Local governments would like to do more in terms of regulating types of firearms, ammunition, places where firearms can be brought. Many states have adopted really blanket prohibitions on local regulation of firearms. The sharing economy is another area where local governments have been very active, trying to deal with entities like Airbnb, and states have pushed back. And of course, immigration and so-called sanctuary, where local governments have adopted a variety of policies designed to be, shall we say, less than cooperative with federal immigration policy, and states have pushed back. Not all of the conflicts are, most of the dramatic conflicts have been red state, blue city, but not all. There have been blue state, red city conflicts or blue state, red counties over immigration and gun control in places like California. And there's even some blue-blue conflict in places like New York, famously about when New York City wanted to adopt its own plastic bag ban, and the state got in the way for a while. So it's not just red state, blue city, but a lot of it is red state, blue city.
Thank you. Professor Davidson, it looks like you have a follow-up.
Yeah, just one additional point to add to Richard's really terrific overview is that one other slice on the state and local conflicts is that most of the things that Richard was just talking about have to do with regulatory authority. A state wants to set a standard, and a local government has a different view on what the appropriate standard is, whether it's in the workplace or the environmental arena or otherwise. But there's a separate set of conflicts, and in some ways I think it's important just to put them on the table because they're important for what we're going to be talking about today, which have to do with the organization, management, and oversight of governance itself, whether that's how you manage elections or how you oversee a municipal workforce, a variety of questions that are really internal to local governance, and we see conflicts in that area as well. And I think that's important to put those kinds of conflicts on the table as well.
Thank you. My next question is for Professor Su. I know that you and Professor Davidson have co-authored a white paper that was just released, and you did it in conjunction with Marissa Roy from the Local Solutions Support Center that deals specifically with these issues of preemption, but within the context of policing. I understand that this is an area that is kind of frequently and constantly developing and evolving. So Professor Su, can you give us kind of an overview of where we are right now when it comes to the intersection of policing specifically and public safety specifically and preemption?
Yeah, so the issues sort of been heating up, and a lot of it is politics. But right now, the big issues that are really affecting, I think, the country with regard to preemption has to deal with essentially response to the movement to defund the police. Now, it's important to clarify that the defund the police movement, despite the use of the name, isn't really about getting rid of police departments altogether. There are many advocates that are really trying to sort of reallocate resources internally within the local government itself. So a lot of it, going back to what Nestor had said earlier, may be seen as sort of an effort to just sort of maintain some sort of budgeting authority over internal governance, right? Different departments, how we should handle specific issues, what department should handle it, how the resources allocated. That issue, of course, has become really political. So one of the biggest ways that we saw this year was with regard to anti-defunding provisions. There were about 25, maybe 26 bills that were proposed in 10 states. 3 of those states have acted on it, Florida, Georgia, and Texas. Essentially, there are some variations between what they do, but they're really tackling this idea of limiting the budget authority of local governments. And I think the way they're designed, really limiting it in a way that is really tackling budget authority as a means of reform, as opposed to just sort of allocation of budget altogether to, let's say, for the purposes of public safety. A perfect example is many of the states provide exceptions to their anti-defunding if, for example, the city's entire municipal budget were to collapse, but doesn't provide any state funding. So it seems to be if you don't have enough money to fund your police department, then public safety maybe not as important. But if you do have enough money and you're maybe adjusting the budget for some other reason, maybe a reform effort, then these anti-defunding bills would impact. It should be noted, however, this is only sort of the tip of the spear. There are a lot of different regulations, and historically going all the way back, where states have sought to control municipal authority over their own police department. That's sort of internal governance issue.
Hank, and I want to use this as a moment to pause and invite our audience members to submit any questions that they may have into the question and answer function on Zoom. We'll be collecting those questions as they come in, and then later on in the conversation, we'll start addressing them. But now that we have kind of an overview, like a 30,000-foot kind of overview of this issue, I want to explore some of the complexities that we're seeing here. Professor Davidson, can you talk about kind of the specific mechanisms that have been used by state governments to enact kind of preemptive measures. We discussed, for example, that oftentimes the conflict arises between political divides that occur at the local and state level. But what are the tools that state officials have at their disposal to enact preemptive legislation, and in what ways have they used those tools specifically within the policing context?
Yeah, so again, most of this comes up with straightforward legislation, but let's unpack the mechanism, for example, in HB1 in Florida, one of these statutes, these recent statutes that Rick talked about that seek to limit the discretion of local governments over police budgeting. So under the structure in HB1, if a local government reduces its police budget, there is an opportunity to appeal that up to a state cabinet made up of the governor and his cabinet. And there are no real standards for how the cabinet can decide what the budget is. And by the way, it opens up, at least the statute purports to open up all budgeting questions once it gets up to that level. So there are mechanisms that essentially withdraw a function. And there's a long history of this. In the white paper that Richard and Rick and Marissa and I worked on, we tied back to some very old history. And police oversight is an area of state-local conflict that really goes back to the 19th century. And there used to be statutes that were called ripper bills, and the title is really evocative because it would rip a municipal function away from local governments. And really that was in an era of conflict over big city change and the growth of a different kind of diversity in cities. And we've had urban-rural conflicts really since the middle of the 19th century, but that was at a moment in the late 19th century when those conflicts were really sharpened. And again, we're seeing similar fault lines now. I'll just say in terms of other mechanisms, much of this just comes from legislation, as Richard mentioned. Some of this is by implication. If the state has a regulatory regime and there's a conflict with an action or a regulation or a choice that a local government makes, there can be a conflict. But increasingly, particularly over the last 10 years, legislation is very directly targeting sometimes all local governments, but in some instances, specific local governments. So a local government will pass a measure and a state will respond in a way that just targets that one local government. And then I'd say during the pandemic, in a moment when governors had a great deal of power, and there are some interesting state level constitutional conflicts between legislatures and governors in many states. But if you look at Florida and Texas and Arizona and states like that, governors have increasingly been exercising executive authority directly and through agencies to rein in what they see as conflicting policy choices at the local level.
Yeah, I want to follow on that a little bit. I mean, it's sort of interesting that in the United States that policing is primarily, right, most of the bulk of policing is primarily a local function, right? We have state police, we of course have a federal, various enforcement forces, whether it's immigration or the FBI. But the bulk of it is at the local level and local departments. But whether or not they are in fact formally a local department and how they operate, right, has always been an open question. As Nestor noted, we sort of had our first police departments established in the 1850s, and 10 years after New York City established their police department, the state took it over, right? They abolished it. They set up the Metropolitan Police Department that was state-run, state-controlled. In fact, interestingly enough, New York PD refused to disband. So there was a time when both were operating and they were kind of fighting each other, like physically. Anyway, that's sort of interesting. But just to give a little bit of layer from that early history and the sort of response to those river bills. And New York City was not alone. Almost every single big city police department had their police department taken over. St. Louis just got theirs back about, within the last 10 years. Kansas City still hasn't. But the politics actually were very similar, right? Because essentially what you had was a partisan divide between the big cities and the state legislature, a demographic divide, right? At that time, most of the big cities were heavy immigrant populations. The state saw them as sort of supporting local political machines. And there was a difference in terms of function and priorities, right? So states thought that local police departments were not prioritizing things that they thought that were important: vice, temperance, prohibition, strike breaking, right? That in Milwaukee, they thought the police department was too supportive of essentially strikers. So there, and of course, all these issues essentially also aligned with the partisan and also ethnic divide, right? Alcohol being sort of Catholic Protestant, a big divide at the time. So a lot of the takeover was also politically motivated by the different demographic profile of what constituted the state legislature and what constituted a lot of these big city demographics. So I'm not surprised that we're seeing similar dynamics happen today with more and more majority minority cities, maybe a little bit difference of opinion with regard to certain issues like drug enforcement, but also, as we're seeing now as well, different sort of impact from the role of police. So there's always a question of, who is going to control the police, right? Which is our primary law enforcement arm, sort of coercive force of the state. Is it going to be the state or is it going to be localities? And even though they're local departments, that question has always lingered, really right from the beginning of police departments founding.
If I can add one more thing on that, a third factor, of course, are the police themselves and the role of police unions in particular in the modern era, not so much right now, although I wouldn't rule it out for right now, but going back 10, 20, 30, 40 years, another area in which states have a big impact, and not actually just on police, although our focus is police, is state laws dealing with public employees generally, police in particular getting things like police officers' bills of rights, which provide special procedural protections when issues are raised with respect to police misconduct, and more generally state laws that deal with bargaining processes, impasse resolution, mandating benefits in certain levels for local employees, police in particular. So this, and in many ways, part of the system is the ability of interest groups to kind of work at different layers at the same time. So if a police union doesn't do well in the local politics, they can take and refight the issue at the state level and get the state to come up with, adopt a kind of what's called a police protective law, focusing really on the police as public employees deserving of employee rights. Also, that's another area where, for example, prohibitions on residency requirements typically will come from that, because at least in many big cities, at least many of the police, of course, were not city residents. So the police themselves are active forces in this and can take advantage of the two-tier nature of the system to sort of pro for the soft spot wherever it may be.
I have a question about the kind of the ethics or the policy behind a lot of these maneuvers, because my understanding is that when we talk about Florida or Texas making moves and enacting kind of preemptive legislation or using executive authority in a preemptive way, it doesn't seem as if we're saying that they are acting beyond what their authority allows them to do, right? Legislatures are empowered to enact laws. Governors are empowered to direct the executive function. So it really seems to, for the most part, boil down to a question of how they should use these powers and whether they should use them in a way that preempts local authority. Assuming that that's the case, why is it at all important to kind of preserve local authority? Why shouldn't states use their powers in this way if they are otherwise empowered to do so? And I'll direct that first to Professor Briffault and then to Professor Davidson.
Sure. A couple of arguments in favor of what might be called localism, or others would call it subsidiarity, as a more general rule of that the government closest to home should be given responsibility so long as it's capable of exercising it. One thing is, in our large states, even in small states, there's just going to be a variety of needs, circumstances, and preferences. And so there may just be philosophical differences. There may be differences in priorities in policing. There just may be differences in urban and rural, in high immigrant, low immigrant, poor and not so poor areas. And local residents may legitimately have different priorities and preferences as to how they want the policing to occur. And so, sort of in some sense, why not? I mean, you would satisfy more preferences, more values that people have if you decentralize the decision-making so that people in each community could get the police function that they want. So that would be one basic idea, is local accountability to local differences and needs. Related to this accountability itself, it's that an oversight may be easier at the local level, when you can actually, the people who actually see and encounter the police on a regular basis, see how well they're doing or how not so well they're doing, or how, when there are questions, are people most likely to want to be able to respond and seek a change. And it's easier to seek change at the local level than having to go to the state level. So there again, there's a kind of an accountability argument there, as well as variation in light of preferences. In some ways, the major argument has always been a sense of government is likely to be more effective and to do more what people want, the more it's closer to home. And the major exceptions are when we reason either there's going to be significant external effects from what is happening, so that there's a need to have a higher level of involvement. If we think the local government's doing a poor job and crime will spill over, if there's some kind of problem like that, that calls for some justification. Or if we think, and this may be more true of small local governments than bigger ones, that they lack the capacity. There's some crime lab. You can't, not every hamlet's going to have its own crime lab. You may need to centralize certain functions. They may be a lack of administrative capacity. And it could be that very close local oversight may also lead to some internal problems if if local majorities are oppressing local minorities. So it's never completely cut and dry, but I think the argument for big local role is always, for me, has always been this combination of enormous variation in needs, preferences, and circumstances across our state, nation, and states, even within our cities, so that the policing ought to appropriately be tailored to local needs, and the greater likelihood of accountability if the people who are directly on the, shall I say, the receiving line, on the encountering line, are also have the greatest opportunity to have influence.
Thank you. Professor Davidson?
Really not much to add to that. I mean, the one thing I would say is that there is also an experimentalist case here that often gets talked about, that Richard's talked about, which is to say, if we want to think differently about how to approach public safety and how to approach policing, and you have a uniform state rule, it makes not just responding to local preferences harder, but it also means that we're not going to be trying new things as often. To have a reform that may be unusual, that may be pushing the outer envelope of what's possible conceptually or practically, doing that at the scale of the state of California or New York or Florida or Texas is much, much harder than doing it at the scale of New York or a smaller community, New York City. Not that anything in New York City is small scale, but I do think it allows us to really have those proverbial laboratories of democracy in a way that perhaps the reform doesn't take, perhaps it's not well advised, perhaps we need to tweak it. If you do that on a statewide basis, that's much, much harder. But if you do it at a much more local level, you get that responsiveness and you get the feedback much more quickly, and you can really innovate, I think, much more often.
Professor Su, do you have a follow-up as well?
Yeah, I want to follow up a little bit on both those comments about accountability and experimentation, because I think that's actually really important to, I think, your efforts, Jorge, but like with regard to police reform, I think right now what we're lacking in the discussion is, what does the alternative look like, right? I mean, we know that there are issues with the police right now, and there are plenty of incremental sort of like maybe a little more supervision, maybe a little more training, but what would be an alternative actually look like? And I think one of the reasons why we haven't really explored that is because there's no models out there, right? State law and really sort of general practice is sort of locked in a current structure that we've had since the 1850s. Even though at various times we've had debates, right? Should traffic enforcement really be a police function, right? We're not talking about, look, everyone's concerned about violent crime. Violent crime is there and the police should handle it. But the thing is, the police does a lot of different things, right? And there are a lot of different priorities that may not be violent crime in different communities, whether it's drugs or immigration or whatnot. And the fact is, police does a lot of social service function at this particular point. So the reason why I don't think we question those things, or we sort of really have an opportunity to probe those roles, is because we really haven't had the opening in which we've tried out different things, different organizations, in which they're then models that people can say, does that work or does not work? So there's sort of a lack of imagination And I think in some ways it's because of the structural lock-in that we have right now, right? People assume the question is police or no police, as opposed to no, is there another way to sort of think about how we sort of provide for public safety or social services, or how we organize it in a different way? And without experimentation or some sort of tailoring to specific communities, you don't even have that opportunity to start that conversation, right? The first thing you hear is just, we can't do it. And that conversation doesn't even start at all.
Thank you. Now, we've talked, for example, about how, again, much of the motivation, or at least much of the basis for some of the preemptive trends we've seen in the past 2 years and even beyond are fed by kind of partisan divides across different levels of government. One thing that struck me in the white paper that Professors Davidson and Su you have published is the notion that many of these measures are kind of nearsighted, that they're intended to strike a political blow to your adversaries by saying, okay, you want to defund your police department, here is a law saying that you cannot do that. But the manner in which those blows are struck can actually have a broader impact than just targeting your political adversaries on this one particular issue. Professor Davidson, can you kind of talk a little bit more about how some of these, again, these preemptive measures can have a broader and unintended impact than what the particular political dispute might have otherwise intended?
It's a great question. And I think it's worth actually going back to your earlier question about if states have the power to supersede local authority, why not? Why should any function be local? And we've talked about the case, which can play out in policing, it can play out in land use, it can play out in lots and lots of different areas where allocation of authority is an issue. And as Richard mentioned, there are downsides as well. Local parochialism, local political process failure. There are lots of reasons why we should be concerned at times about the exercise of local power, and it's always a balance. I do think that when you have an issue that is partisan, that is being driven by very, very specific outcomes, and that really doesn't calibrate to who is responsible for a given function, right? So policing, states have made some broad choice that policing should be primarily a local function. And having made that choice, if the state then, for short-term partisan reasons, reallocates authority, it really isn't in light of any larger principles about what should be local or shouldn't. And it shifts the legal system. And we saw this again. I'll just point back to a lot of state local conflicts during the heart of the pandemic, issues about mask mandates, issues about stay-at-home orders, issues that are currently playing out in a number of states about the authority of schools to protect their students and teachers and staff. And the more these questions become short-term, we've got a demagogue on a given issue to get to the next election, the more you end up with these weird disjunctions. I mean, in Florida right now, you have a governor who is defunding school districts over local public health measures. You have a federal government that's stepping in and using federal funds to backstop. And then the governor is trying to take federal funds away from local governments. We have no idea how that's all going to play out, and a similar set of conflicts are playing out in Florida. But what it does is, I think it takes a set of what hopefully are nothing. There are no neutral principles here, but at least some broad principles that, in the rough and ready, point towards certain issues being mostly local and certain issues being mostly state, and it warps that landscape.
If I could just add, I think it's fair to say that this is an area which has never been governed by principles. People can cite to principles to argue one way or the other, but it's like federalism. When there's a Democratic president, you see the federalism lead is taken by Texas and Florida. And when there's a Republican president, the federalism lead is taken by California and New York. And there's a push for states. And I think on this also, I mean, Nestor's right, the events of the last 2 years have underscored this, has been unprincipled on steroids, has been as political as possible. But I think there's never really been in most of these things, there's never been there are arguments, there are principled arguments about why something should be higher and something should be lower, but they've always been caught up, I think, in the politics of the moment. I mean, education is another area, and not just the stuff about masks, but education policy has been for 40 years, really. The states are formally in charge of education policy. The locals actually deliver education. There's been tension about how much local discretion should there be in shaping the education around local circumstances and needs. States are imposing standards, locals are trying to work with them. In addition to the fights about masking, the fight currently about critical race theory in elementary schools, all of this is some combination of politics and performativity in an area where it's very easy for the states to posture. But knowing that they're ultimately, that they have the power, but ultimately the services are being delivered locally by local employees to locally accountable governments, but yet they're also accountable to the state. So I think the difficulties are hardwired into the system. And as Rick and Nestor pointed out, by going to the Ripper laws of the middle of the 19th century, this problem is this is I think it's both a feature and a bug. It is a feature which is a bug in the system.
Let me, I want to pipe in a little bit here, and it's sort of, I think it's a good question about the unintended consequences or the long-term consequences, right? We know, as Richard said, Nestor said, there are current political fights that are animating this, but I think the big, one of the biggest concerns is not just how we resolve this fight, but whether or not we're going to have unintended consequences going forward. And one thing we noted in the white paper, and I think it's important to know, is that the anti-defunding measure may be targeting police reform efforts. But even if cities don't care about police reform efforts, right, they're still going to be hit by this, right? And in fact, many cities have said, look, we have certain programs that are just right now under the police budget, right? Youth services programs or recreational programs. And we can't move that, right? We can't move that to Parks and Recs or just do internal division. So that's sort of an effect. And interestingly enough, we've had this right from the beginning, right? We've had political fights, right? So some of the earliest funding mandates that happened before. So this is what I wrote in a recent paper that's coming out. But some of the earliest funding mandates that we had before was because the state took control of the police departments, but didn't want to pay for it. So they didn't want cities to have that sort of backdoor way of controlling. So they put funding mandates. But what ended up happening, which I don't think was intended, is that it meant that the police department had all this personnel and funding, and they were always really, really big. And in fact, they didn't have a lot of things to do. So as a result, when the city saw this and they are forced to fund them a certain level and various other functions came up that they wanted to address, they signed it to the police department, right? From sort of dealing with tramps, finding lost children, traffic enforcement, stuff like that. There's a lot of centralization of police departments around this time. Part of it was because they felt that local ward bosses had too much control. So it was an anti-machine, political machine sort of measure. But what that also ended up was leading to this centralization of police agencies that then led to extreme professionalization that then led people to be concerned that they were disconnected from the community, right? That was sort of the early community policing reform. But did they intend to do this, to sort of professionalize and centralize the police? Not clear. It was anti-machine, but it had this sort of effect. And the same with the 20th century, with all the federal grant funding for policing, right? On the war on crime and war on drugs. A lot of that was important, right? Like, there was a current debate, which is the federal government thought drugs and crime were things that we needed to tackle. But what ended up happening for local governments, especially during the fiscal crisis, is they realized if we do things through the police, we get grant funding. So, and a lot of the federal support for social services and other housing and stuff like that, infrastructure, were going away. So as a result, a lot of then dealing with social issues during that time became a policing issue, right? And local governments were swayed by this. Did the federal government want them to do that? No, but they put the money there, they set up a structure, and the unintended consequences is that localities chased the money and they dealt with homelessness and psychiatric problems and everything through policing because we get a matching grant when we do that. So I think there are a lot of unintended consequences that don't resonate in the political fight because they're so enraptured in what's going on right now. But those tend to have the lasting effects and the sort of longer structural effects that become a concern.
We've done a really great job of kind of articulating how daunting a lot of these challenges are, and kind of the effects, both intended and unintended. What are kind of some of the responses? What are some of the potential solutions to kind of overcoming these? In other words, what could localities do, to overcome these obstacles, or what can advocates push for in terms of kind of rebalancing the authority between state and local governments, so as to minimize kind of the politicization of legislating or the use of executive power, while also still preserving, the ability of state governments to enact genuine and meaningful kind of statewide standards for something as critical as policing. It's unrealistic to kind of presume that state governments should have no hand in how policing is managed from a legislative or executive point of view. But at the same time, it's very easy for states to become quite heavy-handed and overly heavy-handed in how they exercise that power. So what would kind of the changes or the possible solutions to these difficulties be?
I guess I'll jump in just to start. One way to think about responding, I certainly think there's a policy response and an advocacy response that tries to surface where the vertical allocation of powers questions play into issues like police reform. And I think forums like this are important because I don't know that we have really paid much attention to the state-local conflicts, even though as Rick and Richard and I have talked about, they've been around since the middle of the 19th century. And it's been a major feature of state-local relations. And I think part of that advocacy can be sharpening what it is that the state role is, right? So one of the things we talk about in the white paper is, for example, you certainly want a floor when it comes to civil rights. And we have a floor nationally, but that is a role that states can usefully play. And again, we talked a little bit about, and Richard talked about this, you can have processes that fail at the local level. And often, of course, this deeply implicates race. And having statewide standards that allow transparency and responsiveness in context where police violate rights, that's got to be beyond any one local government, right? There's at least a floor. Obviously, local governments can be more protective. New York City just this year passed an ordinance, a city ordinance that changes the standards for qualified immunity for the New York City Police Department. So you can imagine local governments being more rights protective, but certainly you want, so as part of the advocacy, I think you want to come back to what in fact is that state interest. And then we can get into more of the details. I do think there are ways to think structurally about not eliminating the state role, but putting at least a higher burden of justification on the state. So what happens in most states, although for those of us who toil in the fields of home rule, there's a standard disclaimer that it varies significantly from state to state and even within states, and big cities are treated differently from small rural communities when it comes to these state local questions. But broadly speaking, in most states, states don't really need much burden of justification. If there's just a plain policy disagreement, local government thinks this is the right way to approach this issue within its jurisdiction and the state disagrees, courts, when the conflict arises, are simply going to defer to the state. Obviously, that's complicated in some contexts, but that's by and large the broad rule. And so one thing you could do, whether it's transsubstantively or in a more targeted way, say for these particular issues or for these state local conflicts, the state needs to meet some kind of a higher burden of justification. And there are different ways you could phrase that and different ways to think about it. But if you take it out of the default presumption that states simply have the authority to make policy and disagree with locals on any issue, that at least gives some space for advocacy and ultimately perhaps courts to scrutinize to some extent the naked assertion of a policy difference.
Yeah, maybe three things. First is, I think, just to pay much more attention to the states. I think states tend to fall between the cracks for most advocates of most everything, actually, and not just in police reform, but in terms of our political system. This is not yet another bewailing of the failure of American civics education. But I think it is true that for most people, the states we know our cities, particularly those of us in big cities like New York or Chicago, And we know the federal government, but people just don't pay enough attention to states. So almost number one is every advocacy office has to have permanent position in their state and to be monitoring the states all the time. If maybe not even to get good things, to just prevent bad things, to discourage the passage of bad legislation. And some of this may be less about getting good new things adopted at the state level and more about just, highlighting the bads that are in the pipeline and maybe organizing to stop them. A second is a bit doctrinal, and it's a softer point. We have been focusing primarily on new state measures or state measures that intentionally and clearly displace local action. But a lot of the law in preemption actually comes from some pre-existing state laws or state laws that address an issue, but don't clearly preempt the locals, but could be argued to do so. But it could be argued by a police union, or it could be argued by some law enforcement group, or it's not just in the law enforcement area, that because the state has entered the area, locals can't do more. This sometimes gets known as the floors and ceilings debate. The state has done something, it's a floor, but people argue it's also a ceiling that prevents more local action. Sometimes it comes up just in the whole idea of implied preemption. And so one thing that the three of us and others have been arguing for is to persuade state courts, may possibly amend a state constitution, but persuade state courts doctrinally to abandon or at least move sharply away from implied preemption. If the state's going to preempt, at least make them do so. Now, some states have had no bashfulness about that, but not every state does, and not all of these issues actually come out of direct preemption. Some of them do come out of implied preemption. The hardest one, and I think your own work has been looking at, is how to think about imposing constraints on express preemption, and that I think is going to be hard. It's going to be hard both coming up with a standard, and it's going to be hard in enforcing that standard, which maybe gets me to circle back to my first point again, which is to keep watching at the state level. And a final one I think would be, and again, this is maybe another loser, but is to sort of, as a matter of both legal reform, but also policy, it's just focus more on trying to separate budget from policy. Many states have kind of formal positions in their constitutions that try and separate appropriations from policymaking. They're honored more in the breach than in reality. And it's often the case that, right, here's $100 million for your police department, provided that you don't do this. And it would be better if the state might still pass the restriction as a policy measure, but it's a lot easier to pass restrictions or mandates in the context of the budget process. I know New York better than any other state. New York makes almost all of its policies through the budget, which is a terrible way of making policy. And again, this is probably more advocacy than a likely change in legal rules, but it would be an avenue to think about trying to forcing a separation of budget from policy, even if that's at least as a goal, even if recognizing it may not happen so much in the short term.
Yeah, I want to sort of pipe in that too. So I think the irony of this whole thing is actually the underlying argument for local control actually, I think, is strong. Like, I think if you take it away from whatever the current political fight is, if you just sort of pulled, I would say, across the aisle, right? Like how people feel about local control over policing, I think is actually quite strong. There's not been a strong support in the United States, despite some people arguing for a national police force, for example, right? And people are always annoyed, right? I mean, TV shows, right? FBI comes in, takes over the case, right? That's presented as a bad thing, right? And certainly, I think one of the interesting about immigration enforcement is how they kind of just swoop in, either it's a small town or a big city, and there's no accountability, right? No one has sort of control over whether it's important. I think there's a sense that people like the idea that the police force is a local force. I think there's a sense where people like the idea that they should be focusing, as Richard had said earlier, on local priorities, that we know what is wrong with our community and what the issues are, and we know how we want to try to approach those. And I think most people would agree that if we're going to pay for it, we should have control over what we're paying for, right? And this, I think, is actually, the funny thing is, one of the arguments being raised against Florida's HB1 is the unfunded mandate, that essentially the state is forcing unfunded mandate. That's a conservative position, right? The idea that local taxpayers don't have control over what taxes are going to go to that they're paying in. So I think actually all that general local control idea is actually really strong and sort of goes and cuts across the aisle. It's just oftentimes these reforms and preemption gets put in precisely because we lose track of that bigger question and we're focusing very specifically on one specific local fight. And I would say the last thing too, I think it's just the general sense of reform, especially on the sort of progressive side, which is for decades have been, we want to go to the top and we want to sort of go from the top down. If we can get federal legislation on this, we don't need to deal with state or local politics. And I would say for most, ambitious, students, they like nothing better to go to Washington. Now, maybe the quagmire and stalemate of all Washington politics is maybe dissuading some individuals, but the idea that these reforms might be bubbling from the ground up, right, sort of supported by local residents in this messy process of local participatory democracy, I don't think reform advocates have really been sort of tapping into that as much as, they say they do, but I don't think they're really doing it. What the sort of top-down approach has really stifled this idea that these sort of energy shift coming from the local level and from the residents themselves.
Thank you. This is actually a great segue into some of the audience questions that we've been receiving. I'm going to combine them because a lot of them touch on similar subject. One question is, relates to kind of the political response, the policy political advocacy response to a lot of these trends that we've discussed, and the opportunities perhaps to actually cross political divides in favor of seeking local support or stronger protections for local authority in ways that again serve both kind of blue and red political interests. What opportunities are there for kind of that type of alliance making? And then as a second question, obviously, when we're talking about these kind of contentious laws and policies, litigation is almost an inevitability of some kind. Audience members have identified cases from Arizona to New Jersey where preemptive efforts against local civilian boards have been challenged in courts, and where the outcomes have been kind of different, where it appears as if some courts may view or identify a constitutional vulnerability to these preemptive efforts, whereas other courts say that states are empowered to enact these preemptive prohibitions. What do we think about kind of the involvement of the courts on this issue and how they may decide some of these questions?
Let me jump in a little bit on both of them. So I'll start with the civilian review boards and the litigation efforts. So one thing, going back to I think what Nestor said a little bit earlier, is a lot of the litigation is going to vary depending on essentially the structure of the state and their state constitutional law and the precedents interpreting it. I don't know if it's, it might be too hard to get into all the details, but there are various state local sort of structures in various states. Home rule, we've mentioned, is some insulation and protection for local governments, some restraint on state law. Those were a response to not only the police ripper bills, but all sorts of police sort of state preemption before. But how those have been interpreted, how those are structured, sometimes offer more protection and less protection. So for example, in certain states like Ohio, the courts have granted a lot more protection for internal governance. They've seen that as sort of an exclusive realm in which the states cannot intrude, or some special protection against special legislation, right? Laws that target only specific cities and not others. Texas's anti-defunding actually has population cutoffs that seem to be very narrowly targeted at major metropolitan areas in that particular regard. So you're going to get variations in that as well. So litigation, I think, may be effective, but they're effective to the degree that the underlying sort of legal principle, whether it's home rule, is viable, right? So whether or not that already exists and whether or not the courts believe it in some particular regard. So it actually gets back to the broader question of, do we believe in local control at all, right? Like in some sense or some sphere in that particular regard. This is also note that litigation, right? The civilian review board thing, that litigation can also then fall to legislation, right? The laws can also change. I didn't mention it, but Arizona recently passed a law that essentially abolished effectively civilian review boards, right? They said that 2/3 of voting members of any advisory, supervisory, overview board has to be composed of law enforcement officials. And then the other 1/3 could be civilians, but they also have to take, essentially, they have to go through a police academy, right? So they don't, anyway, they just got rid of it, right? So like in Tennessee has a, not as bad, but a similar law sort of come into play. With regard to your first question is, how do you cross the aisle? I think local control, as I mentioned before, is somewhere to cross the aisle, but I think there's a bigger question, which is, are we willing, right, depending on what political side you're on, to give grace on certain issues, right? Because I think what ends up happening is, we say, look, localities should have some discretion to enact sanctuary policies to not participate in immigration enforcement. And then we turn around and say, well, this county can't make the decision not to prioritize firearm enforcement, right? Like to just not participate. So as a result, that sort of flares up and the state comes in with anti-sanctuary and then pro Second Amendment sanctuary, right? Like they just sort of like, we're just gonna cut off the debate and we're gonna sort of get into this. There's a double-edged sword to some of this, right? As Richard had mentioned earlier. I think some of the crossing the aisle, if we're really gonna be, I don't know, right, honest about it, is are we willing to tolerate policies that we don't like based on the idea that a locality should be able to decide for themselves? Of course, with Nestor's idea of a baseline, right? But on top of that, or are we willing to say, well, look, if we're going to lose some local control here, we're going to get more control over here, right? And I think that's what's led to this sort of progressive centralization, which is, we'll just wait until the next time we win the presidency or the state house and we'll just strike back. But the ratchet is always just like preempt, and we just can continuously, like immigration policy, flip-flop at the top, right? In this particular regard. And I think there's actually a lot of whiplash there that may not necessarily be good, even if, let's say, half the time we get the policy that we want.
So let me make two small points. One, I think I was just looking at the chat in terms of that Arizona law, which about I read the newspaper article. So although local governments very rarely will win on a clear cut, you're violating our local rights argument. Although in some states, local rights are stronger, more strongly protecting the Constitution. California and Colorado are probably the two most prominent instances. State constitutions have a lot of restrictions on the state lawmaking process. And occasionally one of these measures will stumble and will hit a tripwire. And I think that's what appears to what happened in the Maricopa County decision. Most state constitutions have a so-called single subject rule, limiting every bill to one subject. No one quite knows what a subject is. Subject can be very broad, it can be very narrow. But that occasionally, and I think we together have done a project on preemption more generally, and on an important case dealing with firearms in Pennsylvania. The state law was shot down because it actually tripped the single subject wire. The other one that's already mentioned is the special act ban. Many states have laws prohibiting targeting of individual local governments. Again, those are sometimes ignored, or sometimes they're sidestepped in an effective way. But that can be another one. I mean, the problem with both of them is, of course, the state can come back and next time just do a single subject, or pick up more governments in it. So they're one-time victories. That can matter sometimes if it slows the momentum down. If something is really being done because it's in the heat of contemporary politics, and maybe after 2 years of litigation they have to start over, maybe it won't actually happen. Maybe there'll be a change in the governorship, so there's a veto. So they're not nothing, but they're not strong guarantees. The other is, the hope for what about a conservative belief in localism? I mean, traditionally, at least one strand of conservatives is the hostility of federal government, and that things should be done more decentralized. And I think you see both in the less about the policing, because I'm not as up to speed on it as Rick and Nestor are, but in the preemption battles of the last decade, you see both strands of that. You see almost dispiritingly in some states like Florida, lawmakers saying, no, it's not about decentralization, it's about the states. It's the United States of America, not the United Counties of Florida. And so there's very much, it's the states that are special, not smaller that's special. But occasionally you will see the most extreme measures usually don't pass, the ones that go further to stripping away home rule powers. And there is, I think, some residual localism, even in conservative state legislatures. And it's really, in some ways, it's the hottest of the hot buttons get the attention, immigration, gun rights, things like that, and presumably policing. But I think a lot of it is the heat of the moment. But you do see both. You do see this sense of, no, it's not local, it's state. We're talking about entities that are committed to like ALEC, the American Law Exchange council. They're committed to the states. They don't like locals because it means too many laws. There are too many regulations. They want to centralize it at the state level to prohibit too many local actions. And you even see their city-county affiliate taking the same position, the anti-local position. But you do see some lawmakers, even in conservative states, recognizing the kind of invoking the traditional ideas of the value of small-scale government. So I think it's a possibility. What's been more dispiriting, I think, in the last 10 years is how often it's not recognized that there's the legitimacy of when the local decision doesn't spill over borders, when it's just about having a higher minimum wage in this city, or when it's just about having a plastic bag ban in this town, how the states are willing to ignore that.
I'll just add one thing, because I think it's really important to come back to this and acknowledge it. If we're trying to think about a kind of left-right coalition for some devolution, that race also warps so many of these conversations. And that's been a part, Rick mentioned this before, it's been a part of the background of state-local relations. It's another way of thinking of the urban-rural. But I think the polarization, not just around should we be more libertarian or should we not, but specifically about the identification of big cities. We have many big cities in America now are Black-led, and we've seen a sharpening in the political discourse where policing becomes a proxy, sometimes much more explicitly, but even when not, implicitly. And I think it's important when we think about what the art of the possible here is to recognize that that's going to be a cross current in all of this.
Thank you. We're reaching the end of our time. I do want to ask one more question that came in from the audience, and hopefully we can offer a concise response. But it's a revisitation of our earlier discussion on kind of the respective roles of local and state governments, and this notion that one of the strengths of localism is that you can tailor local solutions to local problems, but that runs kind of counter to the notion that many problems are either intractable at the local level or are better addressed at the state level through the enactment of uniform standards or uniform laws that apply, across localities. How can we kind of, defend and promote localism while also, again, preserving this authority or this responsibility for statewide enactment of statewide standards in a way that, kind of allows us to achieve changes as needed, depending on which avenue is kind of more effective?
Well, we need another hour, I think, or maybe another week on that one. But I'll just put in two sentences that I just mentioned floors and ceilings before, and that's another. I do that too much, but just the idea that it's totally appropriate for states to set basic standards. Hopefully, it may be desirable, frankly, because some local governments are small and don't have the capacity, and could really benefit from a kind of shelf registration of having a certain basic standards that everyone can pick up. The question is finding some space figuring out where it's appropriate to allow what Nestor referred to before as experimentation or innovation, or just tailoring the standards to local circumstances so that when they're not less protective, or somehow permit a range of variation. And we need another couple hours to deal with your full question, but I do think that's one idea that I focus on a lot. State minima are fine, but minima shouldn't always be maxima.
I guess the one small thing with our remaining minute I would add to that, which I completely agree with, is that there are no absolutes. There are no policy areas where it's all local or it's all state. And so the question is how you structure the equilibrium. And I think the equilibrium has been very strongly state-centric. And for all of the reasons we talked about earlier, shifting the equilibrium in a more devolutionary, more localist way doesn't disable the states, but it can change the balance. And so part of the hope is that in that equilibrium, we come to better outcomes, but ones that are clearer about what the state role is, why the state is acting, and the centrality of locals to policing.
Just two small caveats, sort of add-ons to that. I think one thing is to note is that a lot of the preemption we're dealing right now is actually standardless. So a lot of the preemption that's new is not that the state is setting a policy, they're just saying no one can regulate this, or they're just repealing a policy. So it's not that we're replacing it with some sort of statewide uniformity. And so I think that's different, right? Second, what's interesting here is you can actually imagine in some ways, let's say policing more specifically, that this is kind of like the legislative executive divide, right? Certainly the laws, most of the laws that they're enforcing is going to be state law, right? There's going to be some local criminal laws that connected with it. But the policing is the administration, it's the executive side, right? It's the administration. And in some ways, you can have the legislature set the baseline, but the reason why we allow elected executives to then, sort of have prosecutorial discretion, for example, or some discretion how administration is that tailoring effect. So I think you can have both. You can say, look, you're setting this sort of baseline, but in the actual administration, we should have that sort of different accommodation for place, time, and also different circumstances.
Thank you, professors. We've reached the end of our time. Before we go, I want to, again, thank each and every one of you for your participation here and for sharing your insights. I included in the chat box a link to the white paper that Professors Davidson and Sue and Marissa Roy recently published, addressing many of the issues that we've discussed here. It is absolutely worth the read. And I also want to give a plug to our upcoming entry in the Policing Conversation series, which will be held on November 15th from 2 p.m. to 3 p.m. Eastern. It addresses policing data and it identifies what it is, what we can do with it, and why it's so hard to get. We'll be featuring Anna Harvey, the president of the Social Science Research Council and a professor of politics at New York University, and Jonathan Mumolo, assistant professor of politics and public affairs at Princeton University. So hopefully you'll be able to join us for that presentation as well. Thank you, Professors Sue, Davidson, and Briffault, and thank you everyone for tuning in today.